and we appreciate that very much. House Bill 196. What LC number are we working off of, Mr. Chair?
I'm not sure. I just had to borrow one from Representative Miller over there. I'm suspecting this is 280592S. All right. Well, I might want to let Ms. Miller have the copy I borrowed from her.
Go ahead, Chairman Powell.
Thank you, Mr. Chairman and ladies and gentlemen. This is, I think y'all have seen me on this bill a couple of times. This may be the first time I've ever had a bill in Judiciary that passed the full committee, went to rules, was sent back to the subcommittee, and we had a roaring good time the other night. As I had said last night, normally Judiciary isn't a place that I like to hang my hat often, and I've certainly done enough of that this session. But it was all worthwhile watching the subcommittee's action as we watched the adversaries to this bill, who prompted every idea that they could. None of them seemed to carry a lot of validity. But in this bill, there were some changes from the original bill, and it's pretty simple to go through. Section 1 still puts them under the Administrative Procedures Act. Section 2 puts any appeals and such through the, lets you go through the business courts. Section 3 basically allows the growers that are growing the product and refining it down to actually have a retail location on their spot, which would give it a few more in the state. At the end of Section 3 on line 105, this allows the dispensing locations to sell any other THC oil product from any of the other producers. Now, the way that was explained was that all of these growers have a different variety, different techniques. So one might work on or has a product that might help one illness or condition where the others won't. So they can basically sell whoever's got whatever for whichever condition. You get into section, let's see here. Section 5 and 6, this gets into the original language of the bill. If you remember, allowed for the protesters that had standing to have a license. This leaves that language in there, but it's still may instead of shall. Section 8, this gets into a issue that I had discussed with members across the hall at some point if it goes through it. And the question was always brought up, well, how do we move forward with other licensees at a given basis? This basically sets this into the patient level of the medical cannabis cards. You know, in the last, since this thing has drug on for so many years, 7 years ago, we passed this. People in due faith, they went with good faith, they went to their doctors, they were diagnosed with one of the conditions or whatever. They paid for that. They went and got a medical cannabis card from the health department. That was 7 years ago. 4 years ago, 4 sessions ago, much to the joy and glee of the legislature, we thought we were doing something that was going to get this product moving forward. 4 years ago, ladies and gentlemen, it still hadn't happened because of certain things that happened with the Cannabis Commission. It was drug out. There was issues made. There were protests filed. And I have to say, from the position of chairing regulated industries and hearings we had last year, we had to ferret out from the protesters and from everybody else. We had to ferret out the process. And it was absolutely the worst process that we could have imagined at that time by looking at comparable bids and information. I mean, it just defies any explanation. But, you know, I'm past the point of criticizing the bureaucracy of this state. It's time that we move on. And that's what this basically does. You go on down, more language on the business courts in Section 9. And then, of course, you've added 2 new diseases to this, ulcerated colitis and, yes, sir. That's ever how you pronounce that. and that was put in. And that, ladies and gentlemen, is what this does. I'm certainly open. I'm at the will of this committee. Um, you know, it's not what I had originally proposed. I guess, unfortunately, I'm more of a straight shooter than I was anything, and I was going for the direct way to curing this thing in the original bill that y'all passed out. In that original bill, it would have given the protesters a license. And that would have got them out of the court system. It would have got them out of the Court of Appeals. It would have got cleared the decks on everything so that we would have got onto this. This is a different way of doing it, and I think it's probably going to take some tweaking at the will of this committee and through the process to get it cleaned up and it moves forward. That, ladies and gentlemen, is what I'm asking the committee to pass this on forward. I will bow to the wisdom of the committee on however y'all wish to clean it up or leave it the way it is. But it needs to be moving forward. As you know, we're running out of days, and this is a very serious issue to the people of the state of Georgia who have created a situation that they have faith in us. You know, those people who don't think that medical cannabis has a role, well, I say that defies the natures of a lot of the folks in science and medicine today. And that, Mr. Chairman, is the story of this bill.
Thank you, Mr. Chairman. Appreciate your hard work on this. I can tell you that I had a couple of new members talking about your masterful handling of the subject material, and I always tell everybody that if you want to see a chairman that knows their material, look at Chairman Powell. So thank you.
I take that as a high compliment.
Any questions from members of the committee? I know, and I appreciate a lot of y'all having sat in on the subcommittee that heard this. That's, if you've got the time and can do that, I always appreciate y'all doing that. It makes this process much better. Number 6 over there, that Representative Fleming.
Thank you, Mr. Chairman. Chairman Powell, yeah, I want you carrying my bills too. The question that I have is still the same one I mentioned to you the first time we talked about this. We've had a long, drawn-out process that evidently has had some problems. I don't think anybody disputes that. And I want to make the situation better, not worse. And under sections 5 and 6, it looks like we're going to give out more license than the original legislation. I just want to be clear, first of all, on how many more can now be given out than the first process that we started. I'm reading the numbers there, but I want to put it in the right context.
Well, this is a clean sheet. I don't have my notes, but if you look in section 5 and 6.
Yes, sir, 5 and 6.
I can only compare to the original bill. The original bill, you have 2 that were granted class 1 licenses, and they're in operation today. You had 4 that were tentatively granted, but they're on hold due to the TROs.
Okay.
Then there were 8 at that time, and I think it's gone up to 9 because there was 1 that didn't participate in the actions, and they're held in the court, but went a different direction, and they have cases pending also, separately from the rest of them. So I think it goes to a maximum of 15 licenses.
So we're going from what to what? First process, how many?
6.
Second process, how many?
Well, the original handiwork 4 years ago was the governor's office and the study committees recommended 12. Went through the legislative process, it left the House, went to the Senate. They wanted 3, it wound up at 6, which was still drastically under what was supposedly the right number.
So the legislation we passed
6.
initially was 6,
We
okay.
passed 6.
And what does this piece of legislation
This
do?
would take it to 15 total.
15 total. Okay. So really 9 more, basically.
9 more, which would be the exact number of the protesters. But in this language, it doesn't mandate that it goes to those protesters, and that maybe should be some of the language that.
So I have been able to be in some of the hearings, and I have missed some because of other committees I had to go to. But let me ask you the same question. See if this process has led you to an answer or maybe a different one. If I'm one of the original people that got this license, and the state after that process awards more, I'm wondering if those original folks are now going to file suits because we had a process and then we basically changed it. Any insight on what this legislation is going to help or hurt that situation?
Chairman Powell, can you pull that up a little bit closer to you, the microphone?
I'm sorry. To my good friend, as you know, I'm not an attorney, but I am as dim-witted as I can be at times. I do pay a lot of attention. And I have listened to an awful lot of you attorneys that have shown me a lot of things and taught me an awful lot over the ways. But we knew that there was going to be a barrage of the folks who were opposed to this bill, and I think you need to know why they're opposed. Right now, you got two class ones that have been building out. They're ready to start selling. They have a monopoly or a biopoly in this state right now. And for every day that goes by that they're permitted without the rest of these folks getting into it is the tune of millions and millions of dollars in profit. There's no competition to them right now. So when subcommittee heard this language, the guys with alligator shoes and they were slick talking, but at the end of the day, there's case law galore that the state legislature has the right to pass legislation as long as it's not unconstitutional. And that argument about diminished value, well, there's nothing says that at any time we can't add more numbers to anything. So, we are the legislature. And as long as we pass legislation that's not unconstitutional, then there's no grounds for a lawsuit.
Number 16 over there, is that Representative Byrd?
Thank you. And thank you for all your hard work on this bill. I'm just still trying to get. So if you go to a physician, they give you a card so that you now are able to get medical marijuana. Is that correct?
That is correct.
So now when you open these stores, who will be able to go? Only the people that have the cards?
Only the people who have been deemed a medical necessity that meet one of these. If you look on the last sheeters too, you've got probably, 20 different diseases here. Once a doctor determines that you qualify for that, then they sign off on the right to possess medical cannabis, low THC cannabis. Then you go to the health department, the county health departments, and you then file, I think it's a $35 or $40 charge or something, and they give you a nice shiny little card that says that you're eligible. You take that card, and when these facilities are open, then you go to them and then you buy whatever the product that you need.
But only those persons that have the card.
Only those persons that have the card. This isn't like going to other states where it's just basically open to any and all people. You got to prove you have a disease, or a doctor has to sign off on it, and then you go to the facility.
So further follow-up, please. So originally, which I was not here at the time, it was for, I think, approximately 12,000 people.
I don't remember how many there were at the start. I thought it was somewhat interesting at the time that we had higher numbers of people at that time that had possessed them, because they were actually thinking this thing was going to pass. It was going to be into effect. So they built up a certain number. And then in the last few years, because of the failure of the system, they've let them expire. So the number is down. I think there's still some 20-something thousand of these cards maybe in effect right now. But, it has the potential that once things are in operation, you'll see those numbers drastically go up in number.
So do we have any idea? I mean, we're talking, a million people, 250,000. Do we have any idea?
I don't think anybody would know at that point. It'd just be a wag at that point.
Thank you.
Thank you.
Representative Kendrick.
Thank you, Mr. Chair. Going back to Representative Fleming's question, Representative Powell, you'll remember that there was an attorney who produced a contract that stated it had the terms in there stating that the people who were awarded the licenses signed a contract saying that rules could be changed, the legislature could come in and change the law, and they consented to that in that particular contract. Now, obviously, you can't sue people, stop people from suing, but I assume if they tried to do that, it would be dismissed since they did sign that contract.
And thank you for reminding me that, yes, that was produced in the subcommittee. The part of the application process basically signed off that you have no rights to sue any further because it's the right of the state to increase numbers.
Okay.
Maybe one of the few things that was done right in that original bill, quite honestly.
Looks like that's all the questions. We got anybody signed up to talk to this? Anybody? All right, Attorney General Emeritus, good to have you with us again. You were here the other night pretty late. Mr. Attorney General Emeritus, what I'm gonna do is I'm gonna give you 4 minutes, and whenever you hit 4 minutes, that's a hard stop. So good to see you again.
Good to see you. Thank you. As I look at the new version, it seems to me Section 8 is the one that's most different. If Chairman Powell would have presented to you what y'all moved forward at the last meeting, I wouldn't be talking to you. Section 8, starting on line 189, I think is an issue because once again, we're rewarding the folks that sued the state with automatic licenses. And Mr. Chairman, I apologize. I only have 4 or 5 of these. That's the scoring that's on the GMCC website. If you go down 4, just 4, you get to a score of 770. My client had a 970 out of 1,000. If you go down 4, it's 770. I think under Chairman Powell's bill, you'd go down 6. And my concern is if you're giving people automatic licenses, rather than having the Cannabis Commission evaluate their competency, I think that's a really poor message that you're sending the state of Georgia and its citizens. If the GMCC finds that they are qualified, competent, I'm not talking to you. But when you automatically give licenses to folks that sued the state and you're telling GMCC that they have to go by that list, I'm not really thinking that scores in the 700 and 600 should be receiving a medical license to produce, grow, and sell. And that's the limit of my comments, Mr. Chairman.
Thank you. Any questions for Attorney General Emeritus? You got one?
Yes.
Okay. Okay, gotcha. Oh, well, hold on a minute. We found one. Vice Chairman Reeves, I'm trusting this will be a brief one, right?
Absolutely. I missed that on the presentation. If you can tell us a little bit more about what you understand the change to be to Section 8 from the subcommittee the other night.
So Section 8 in the version that came out of the subcommittee literally just said you give additional class 2 for every 5,000 and an additional class 1 for 10,000. When you look at the bill in front of you, starting on approximately line 189, that's totally new. This is the first time that language is in your bill. And what that says is that the initial licenses are awarded, but then pursuant to the competitive application process, that post-award process should be viewed next for the new licenses. So that means you're going down on that list for their scoring. So under this bill, you'd in theory be going down at least 6. I candidly don't know what the number is going down 6. I know 4 is 770. It seems to me that our patients in this state deserve the highest quality product. And that's my point. When you're rewarding folks that sued the state, rather than having the state agency assure that the product is safe and reliable, that's a problem. That's my point. And as I said, if he didn't add Section 8 in this bill, which rewards the folks who sued the state, I wouldn't have testified. Thank you.
Thank you. You know, growing up, you hear about folks that are in statewide office. And what year were you elected? 2010. So I was finishing up freshman year, going into sophomore year. You never think growing up that you'll have people that are former statewide officials that come speak before your committee. And I want to thank you for being with us. Appreciate that. Thank you for the work for our state. Anybody else signed up? We got somebody over here. Somebody. Les. Hey, Les. Sorry. Didn't see you back there at first. And let's just, we know who you are, but just for the record, who you are and who you with.
Les Schneider with Wimbley and Lawson. And again, there is no perfect answer today on this. I agree with Representative Powell. The thing needs to move forward, even notwithstanding the objection from Representative Olin, from former Attorney General Olins. He is assuming that everything that was done by the Cannabis Commission and the scoring was correct. Obviously, the litigation questions that. Representative Powell brought before you a bill that would put full closure on it. If we don't want to go with full closure, but at least keep this thing in play to try to come up with the best solution, we would ask to be passed. There is no evidence to suggest that those other scores would make those people not competent to produce that the drugs that are being asked for. So we would ask for you to pass it as is and let it work through the legislative process so we can have a resolution to this matter rather than prolonged litigation. The same issue that occurred here occurred in Florida on the scoring issue, and as I pointed out last time, the judge there ultimately awarded it without any reevaluation of the scores. So I would ask that you pass this out as is.
Representative Fleming, you must got good and rested up for this week over the weekend.
All weekend long, Mr. Chairman, all weekend long. Counselor, my
Yes.
question goes to what Attorney General Owens asked.
Mhm.
Do you agree that what is in Section 8 is not what came out of subcommittee?
Yeah, it came out of, not out of the second vote. Out of the first vote is exactly what was in subcommittee, that we awarded it initially. Here, it's taking a different approach to say, I think to some extent what Representative Silcox talked about, that as the register grows, there would be additional licensees. But yes, there's a difference between what's passed out from the subcommittee to here. And this is to take into consideration and an approach to eliminate the litigation. If in fact all of the protesters saw that they were going to have a path to a license, that might be a indication of how the litigation can go away and we could move forward with the industry.
But Section 8, as it currently stands, is not the Section 8 that was recommended to this full committee by the subcommittee.
Up to line 189, I think it was. That's when they talked about the 5,000 patients and the 10,000 patients. The additional part, where, as Representative Powell indicated, that this would be addressing the people who still have standing and how to deal with that issue. But they still wouldn't automatically get it.
I just want to make sure. I want to make sure I understand you.
Mhm.
Section 8 is not the Section 8, the same one that was recommended to us by the subcommittee. Is that correct?
Up to line 189, it was. After that, it was not.
So the answer would be it is not, and then you can make comments.
Yeah,
but I want to make sure we're on the same page.
Yes, from
Okay.
189 to 201, that was what was in the previous bill. And from 182 to 189, that was in the subcommittee bill.
Thank you.
Sure.
Looks like that's it, Les. Good
Thank
to see you.
Thank you.
Anybody else? All right. Chairman Powell, I'll give you the final say.
Thank you again, Mr. Chairman and committee members. I'm not quite sure, as y'all may have remembered in the subcommittee, I was very open to the fact that the substitute that was brought to that study subcommittee was not my substitute. I took a very direct course, and I don't apologize if I see a problem, that I take a very straight line approach to fix the problem. My distinguished friend, the former Attorney General, has got a client in this, so he's going to find whatever he can. And the argument has been about why we're doing these extra folks that have standing because they protested. They may not have had the highest scores, but they did go through the process. They took it the next step. They filed their protest because they had been wronged in their opinion. And I also think that they were right. I don't know who actually got the right scores. Personally, I don't think any of the scores were given that were right. We know that a couple of the folks, there were some other inconsistencies. And remember, this whole issue was supposed to be, these growers were supposed to be Georgia-based companies. And I hate to dispute the fact that because you have minority participation and you're out of Florida and you hire a former football player and you hire a peanut farmer, that nothing is more sacred than Georgia football and peanuts. It doesn't necessarily make you a Georgia-based company. There was testimony that was given at that time about family members that might have been. I never did get the answer about that because I never saw a lawyer and a person eat up a seat in a chair, in a witness chair, more than they did about people who had been charged with bribery and stuff like that. But it all goes back to what I had told y'all to start with at the last meeting I was here. This is about money. This is about money, ladies and gentlemen. None of these companies have applied are going to win the Mother Teresa Humanitarian Award. These folks are out there to make money and to go forward. And the beneficiary is just like pharmaceutical companies that deal with people that need their product. People need this product. Now, I'm not sure what was in here. I had to ask for a copy of this, quite frankly. So I don't know if this is what passed out of the subcommittee or not. I can't imagine that anybody could have added something to this. But, I will still refute that claim that these people who file suit, they're the ones that are keeping it tied down right now because they had rights to litigate. They felt they were wrong. They had their investments into this, into their applications. So mine is all about moving forward. Even this isn't my product. It's my total product. Some of it is, but it's about trying to fix this situation. And I would certainly ask this committee to move this bill forward. And if y'all have the discretion, if y'all want to make changes, just tell me the changes you're going to make and I'll explain it.
Thank you, Mr.
And
Chairman.
I thank you.
Just sit right there for a minute. Hearing that, any discussion? Number 5, Representative Neal.
Yes, sir. Thank you to the chairman. And thank you for the conversation. So being that you said that this isn't the bill you presented prior to, and being that you said we all know that this is not the bill that came out of the subcommittee, would you be open to just taking out the language that you didn't originally, that was not in the original bill from subcommittee?
Of this committee, and I'm certainly willing to live with that to move this thing forward into the process.
Gotcha. Okay, thank you.
Anybody else? All right. Do I hear a move? Move do pass. Do I hear a second? Moving a second. Members of the committee, I'm going to propose an amendment. I just call it the Smith Amendment. I'd be interested to hear Chairman Powell's comments on it. On line 139, where you see may, strike that and make a shall. Then on line 151, strike the may and put a shall. And
Sorry,
then
that was
starting
on line, what was that one on line?
151 and 159 make the 139 and 151, sorry. And then we'll change the mays to the shall, or to shall, on line 139 and line 151. Then go with me to line 189, right after the period after 2023. Strike starting at the all the way to line 201. And I can repeat that again, starting at line 189, after the period following 2023, strike starting at the word the, all the way to the period on line 201. And that's the amendment. Take a look at it for a minute. If you need me to repeat it, I understand I have a pretty thick accent. I apologize, I still had my mic on. I learned from my grandfather many years ago in a hayfield, just making little noises while you're working. Helps it go along. not always just gospel. It might be a little AC/DC too. All right. Discussion number 18. Majority or Minority Caucus Treasurer Roberts.
Thank you, Mr. Chair. This has gone through several reiterations, but is it my understanding that by making the amendments you just made, we basically took it back to what it was in the very beginning?
That is correct.
Okay, thank you.
Minus the mays to shalls. No. No, not the one that come out of subcommittee. You're thinking about the last one before, Phil. Sorry. Number 12.
I think it's a correlated point of clarification. The first requested amendment, we're changing may to shall on the licenses already granted, the 4 are already granted, correct?
Mhm.
And then will that be one amendment? 'Cause the second part of your amendment will be a policy distinction.
There's one whole amendment. There's 2
Okay,
parts to
thank
it.
you. Appreciate it. Just making sure.
Thank you. Thank you. Bear with me. Okay, strike that back out. We're going to change the mays on line 140 and 152 to shalls. Representative Fleming.
Mr. Chairman, I thought I had a question, but right now the question is, what is your amendment now?
So instead of on line 151,
Yes, sir.
that's going to stay 151. That may shall stay a may. The may on 152 will be a shall. And then on line 139, we're going to leave out a may, but change the may in line 140 to a shall.
So practically speaking, what do we just do if we pass those 2 amendments?
This gives the commission the ability to issue or requires them to issue 4 additional class 1 production licenses and up to 7 class 2 production licenses.
So
Class 2, yeah.
So on line 140, we're changing a may to shall.
Yeah, that's correct.
So it will read the commission shall issue up to 4 additional class
Yes,
1
sir,
licenses.
that's correct.
All right, here was my question. I know how a commission may issue up to 4 licenses. That means you can issue 1, 2, 3, or 4, or 0.
Mhm.
I don't know how a commission shall issue up to 4 additional licenses. What does that mean?
Yes, sir. Well, if you'll go ahead and read on down in the bill, I'm sorry you wasn't here for part of that conversation. You'll look that these are, I won't say it's under section 8, the part we're leaving in there. Those are issued with an increase of every 5,000 patients for class 2. And then for every 10,000, increase of 10,000 patients, that's an additional Class 1 production license. Any other questions?
For how does a commission shall issue up to 4? I'm missing something here.
It's pretty plain reading, Representative Fleming. All right. Any other discussion? Chairman Powell. I hadn't forgot about you.
I'm thoroughly confused, but that's all right. It's not the first time.
You probably remember that Joe Walsh song, Life of Illusion.
Absolutely. So if I understand that we're replacing, we're going to leave May on line 139, go from May to shall on 140.
Yes, sir.
On 151, are we still going to leave shall at May or go back to May?
We're going to leave out of May on that
Leave
line.
out of May.
But we're going to change the May to shall on 152.
All right.
Number 12.
Thank you, Mr. Chairman. I apologize for my confusion. We're making both classes shall. I heard you say shall for the 4, but is it shall for the 7 correct? A requirement? I'd have a question for the author of the bill. If that were true, if we're issuing 15 licenses, do you have any idea on how much production would be in Georgia with those 15 licenses?
I have absolutely no idea.
So what would be the policy rationale to require licenses that we have no idea the production amount that would be in our state regulated?
You know, I think that's just a wild guess, Representative. I'm a firm believer of the free market process. Originally, I know this, I'd said earlier, the original intent 4 years ago was to issue 12 licenses. We knew at that time that based on population statistics about these medical grow operations, that based on Georgia's population, that Georgia should have been somewhere in the neighborhood of 20 grow operations. If that's too many, then the free enterprise system is going to probably put some of them out of business, quite honestly. It's like anything else. If there's an overabundance, and it's not going to go. Or it may create some ingenuity in the medical arts and cross hybridization and things like that. They're changing this thing on a daily basis. You know, 4 or 7 years ago when we started down this road, at that time it was all about low cannabis. Since that time now, a lot of these sciences that are exacted, they're blending the low THC, low CDB. So, you know, they're saying there's a lot of benefits to this. So, you know, that being said, I don't know, but I think the free market as usual will take care of these type of situations.
Okay. I'll call a question on the amendment. Or excuse me. Do I hear a motion on the amendment? Number 5.
I move.
All right. So move. Do I hear a second? Do I hear a second? All those in favor of the Smith amendment? Yeah. Shoot, yeah. Go ahead, Representative Fleming. This is Smith amendment, Representative Fleming.
But what is this with the, that's my question.
On line 140, you're changing the may to shall. On line 152, you're changing the may to a shall. And then on line 189, right after the period, following the 2023, starting at thee, we will strike all the way down to line 201 to the period. I proposed them together, Representative Fleming. Any further discussion? All right. All those in favor of the Smith amendment say aye. Aye. All those opposed, no. Well, that clearly don't pass. All right. No, I can hear pretty good. I've had ear surgeries. I can hear a flea actually. All right. So we're in the posture of passing the whole bill. Do I hear a move? Oh, yeah. Yeah, excuse me. We've already had a move on the whole bill. All right. All those in favor say aye. Aye. All those opposed, no? No. All right. Raise your hand if you voted aye. And this is LC number 280592S without any amendments. All right. All right. Put your hands down. All those against, raise your hands. Passes 7-5. Congratulations, Mr. Chairman. We'll sign your committee request form for rules, send you back up there.
Well, I thank you. Now maybe somebody can tell me exactly what this does.
Yes, sir. All right. Next up, we have Representative Rick Townsend. House Bill 181.